resume, Mr. Miller, there are a couple of points that have occurred to us which I think I should mention to you to give you an opportunity of dealing with them at some point. One is, we would find it helpful to know whether these end-of-life cases only come to court where there is a dispute between the parents and the treating physicians, or whether there are cases that come to court, end-of-life cases that come to court where there is no such dispute. That's the first point. The second point is, it seems to us that some of the arguments about the controversy in social media, attacks on the doctors and so forth, may have greater force at the time of the end-of-life proceedings or in the immediate aftermath than they might have several years later. And so so there's a thought in our mind about the effect of the lapse of time on the strength of some of the, on the balance, if you like, of the relevant considerations. But I don't want to take you out of your order, but I've mentioned those points to give you a chance to deal with them at some point.
I'm grateful. Can I just, before resuming where I was, give you my thoughts on the Section 7 point, which I've considered?
Yes, thank you.
I think, as was instinctively my response when Your Lordship raised it, our answer is that this is a bit more cogent than where I was before. The Human Rights Act is engaged and applied because Section 6.1 is mandatory. A public authority cannot act unlawfully, incompatibly with the convention right that's in play before it. And the court is a public authority. So if it considers that the positive obligation is engaged, it must act to protect Article 8. Otherwise, it would be acting unlawfully. And it seems to us that's what Lord Roger was saying in the GNM case. And there is a species of these cases. This is not one of them, but in the Kuja case, what happened at the Crown Court was an example of this, which was somebody said something in open court that was reportable about the claimant.
Yes, he wasn't a part of the defendants, but he was named by a complainer in the course of her evidence.
In conjunction with a very serious allegation.
Yes.
And it is the case, I don't want to give evidence here, but it is the case, one's experience in Court 12 and 13 in particular, in media cases, that the High Court judges do make orders of this sort proactively, where stuff comes out in open court that would interfere with somebody's Article 8 rights. A witness says something completely out of the blue that is very damaging to a victim of a sexual offence or something like that. And it seems to us that what this jurisdiction contemplates is the court having not just the power, but the duty to act in that situation if that happens. The facts are everything. It depends on what the facts are before the court. Section 7, it seems to us, is looking at a different thing. Section 7 is permissive and limiting. So you get the statement of when you may bring proceedings under the when you may bring a claim that a public authority has acted or proposes to act in a way which is made unlawful, or may rely on the convention right in those circumstances. But it's limiting because it then says, but you've got to be a victim, right? So you can't be Fred Smith over there who has nothing to do with the case. You could have Locus. and you must be sufficiently closely connected with the proposed, with the act complained of, the proposal to act in a way that's made unlawful, that you have victim status in convention law. Now, we're not sure that, I have to say, not sure that Parliament was contemplating the Lord Rogers type situation when it made this provision. But if it does apply, you would be a victim in that situation. We've made the point in the case, and it's trite, that if you're the loser in the Article 8, Article 10 balance, you can go to Strasbourg saying, I've been a victim of a violation of my Article 8 or Article 10 right. So failure to find the positive obligation or failure to act sufficiently on it does make you a victim. That's the prospective outcome that you're looking at. And I suppose then the answer would be, if it applies and one has to come within it, would be 1B, that you wouldn't have to bring a claim, but you could, if you were before the court, you could rely on the convention right or rights concerned in any legal proceedings. But our primary point is that in the first type of case, the person may not even be there before the court. The court may be acting proactively to protect the rights of somebody who's not legally represented, who isn't making an application, there's no claim. And the risk is you start to put form over substance if Section 7 precludes the court doing that. And I do repeat, that was precisely the situation in re BBC. The suspect, the defendant in the criminal case, didn't want anything to do with the proceedings. You will see this in the report, to the point where the court had to appoint an advocate to the court. So there was no assertion of the Article 8 right. Lord Panic raised it as the advocate to the court, but there was no assertion. But the court, the constant theme in the judgments in re BBC is that if the court thinks it has to act in this situation, it must do so. And the reason is to avoid acting unlawfully, which is prohibited by Section 6.1. So I think that's our answer to that. So to come back to where I was in the submissions, I was just dealing with finally with the ward point. And there is a section in the President's judgment at 90 to 96, at page 342 to 343, which the court will have read. This is the passage where he says at 95, quite pointedly, the time has come to draw a line under A versus Ward, insofar as it purported to establish that anonymity is not to be afforded to a class of professionals unless there are compelling reasons for doing so. That's the first three lines of paragraph 95. And his reasons, if you follow through those paragraphs, 90 to 96, were essentially these. One, the potential for harassment and vilification of clinicians online is much greater in 2021, and this problem is indicated by evidence in the Gard and Evans cases, which I'll come to in a moment. That's paragraphs 90 to 92. Secondly, it was not an approach that had been followed by any other family division judges or endorsed by the Court of Appeal. That's paragraph 93. Thirdly, it was not supported by any other authority or any authority cited by Sir James, and was at odds with the principle identified in Re S that precedence shouldn't be given to one of the articles of the Convention over the other. That's paragraph 94. And finally, fourthly and finally, and we would say powerfully, his observation at 96, to the effect it's simply wrong as a matter of principle for the courts to say that conscientious and caring professionals who've not been found at fault in any manner should be at risk of harassment and vilification, simply for doing their job. And we agree with all those reasons for saying it's time to draw a line under Ward. I mentioned the parents' third argument, and we've covered this to some extent. This was in Abbasi before the President, which was the point that we discussed about whether you can prohibit publication of particular information because somebody else may act in a particularly bad way if it's published. This submission did not find favour with the President, And as I've said, there are a number of domestic cases since the Human Rights Act in which the courts have done this to protect the Article 8 rights of a person the court is concerned about. And as I've also said, the cases are not cases where there's any reason to suggest that the evidence, the information concerned is itself sensitive. It may just be a name recognised in the community or an address. So those are the Venables cases. The two other cases that I said I would mention, and are in the bundle, are AM versus News Group, which I did touch on, which is at 1962, which was an interim injunction application involving the suggestion that the address of Abu Qatada, a notorious terrorist, or suspected terrorist, would be published in the mainstream media, called A&M versus News Group. It's a judgment of Mr. Justice Tugendhat. It's a bit...
just before we look at it, I've just been looking at Read BBC just to check the Section 7 point. In Read BBC, the anonymity order had been made by the House of Lords in the Attorney General's reference. And in those proceedings, the defendant was represented.
In those proceedings, yes.
And the BBC subsequently applied for the recall of the interim injunction, or whatever it was, the order.
Reporting restrictions order.
And the defendant didn't take part in those proceedings.
Yes.
But the House of Lords made it clear that the order that they had made in the earlier proceedings where he was represented could have been made under the Human Rights Act.
Correct. Yeah. And probably shouldn't have been made under the 73
rules that they had made.
Yes. So in effect, it became, they were a bit cautious about saying it was definitely wrong to make the order, but they were pretty clear it was wrong to make. Yeah. So it became a sort of freestanding argument without the participation of the defendant. Yeah. AM is at 1962, and the concern there was that if the newspapers published the address, which they were clearly interested in doing, others would attend at the address and cause distress to they would protest or whatever outside the address and cause distress to the landlord and others there. It's not really clear whether the family are living there or not, but if you look at paragraph 6, I think it is, in the judgment of Mr. Justice Tugendhat, there was witness evidence that from the landlord and from her and from the solicitor for Abu Qatada, that what would happen is that his family would be harassed out of their family home if the address was published. There were a number of children as well as a wife, and that was the concern. It wasn't that the newspapers would somehow incite that. That was just going to happen because of his notoriety, which was the point that we mentioned before. Possibly an even better example is at 2357, which is the Green Corns and Claverley case. Again, a judgment of Mr. Justice Tugendhat, who's a very experienced specialist in the Media and Communications Court, indeed in charge of the list, so no stranger to balancing Article 8 and Article 10. And in this case, he prohibited, I'll take you straight to the paragraph, but I'll just tell you what the point is. he prohibited reporting in local newspapers in the West Midlands of the addresses of current and planned homes in the area for troubled children. And it was because of concerns that the homes would be targeted by local residents protesting against the establishment of the homes in their area, a sort of NIMBY protest. Interfering with the Article 8 rights of the children and their carers. And you get that most strongly at paragraph 104. The judge thought long and hard about it.
So this is an action brought by whom?
By the carers.
By the carers.
Not by the carers of the children. So they were asserting the rights of. I mean, they were an NGO. They were a care provider, but they were asserting the rights of the children and the carers. And 105 in a democratic society, protest must be lawful. But there was evidence before the court about, somewhat concerningly, about people power being used against the homes to prevent them being set up or continuing. And he said, if it refers to one group of people compelling another to abandon lawful activities under threat of harassment or violence, it's the opposite of democratic. But there was no suggestion in the case that the newspapers were not going to engage in anything other than proper public interest reporting. There was public interest concern. The judge accepted there was concern about those homes being cited in those areas. They weren't going to incite the protests or incite violence. What was of concern is that people would find out from the local newspaper the address in that road of the potential home or the prospective home. One reason that I mention this is that the intervention by the FSU, Free Speech Union, reviews a number of speech cases in Strasbourg to try and suggest that the risk of third-party abuse or violence, I think this is at page 255 in the bundle, in their intervention, can only be relied on to restrict the parent's speech if the parent's speech would incite such abuse or violence. And they cite, for the proposition at paragraph 23, a case called Dilipak versus Turkey, and it seems that that may be part of the parent's case here. They may be adopting what the FSU says about that. And I just wanted to make this point, that the series of Strasbourg cases that are, I mean, we can't look at all of them because there are a lot of them. They are in the bundle. The series of Strasbourg cases that are cited by the FSU for that proposition at paragraphs 23 to 27 in their intervention were not cases where privacy rights were being balanced against the Article 10 right. They were not horizontal application cases. They were very familiar cases of hard-hitting political speech that the state had penalised. They're mainly Turkish and Russian cases. So the state had criminally penalised the speech and was trying to justify the penalty in Strasbourg on grounds of territorial integrity, national security, prevention of disorder, and so on. It's a well-known line of cases. They're a million miles removed from what we're looking at in the Venables line of cases, or Greencorns, or AM versus News Group, which don't, the domestic cases, which simply don't support that proposition. And in any event, at paragraph 26 in the intervention, they cite, I won't take you to it, but I'll give you the reference, a case called Perenchek versus Switzerland, which is at 4061, in which the Strasbourg court gives some general observations about third-party reaction to speech cases. When they come to Strasbourg under Article 10, because the speaker has been penalised, And they say at paragraph 205, which is at 4147, that they may be influenced, whether there's a violation of it, Article 10 may be influenced by whether there's a tense social background. So it's a pretty obvious point. You know, the state may penalise that sort of speech if it's about Kurdish independence or inclines people to terrorism or something in Turkey. But at 208, at 4148, the Strasbourg court recognises that it's always going to be highly context-specific whether you can act against a person's speech because of how others will react to it. So we're not really sure what to make of this intervention or these points. I mean, our argument, for what it's worth, is there is something of a tense social background in this situation, certainly in cases where there are contested end-of-life proceedings and there is the prospect of that sort of activity on social media of the sort that we've seen. It's not political speech, it's not the same sort of thing, but facts are everything in these cases. But there's certainly no bar in Strasbourg in an Article 8 versus 10 case to falling on the Article 8 side just because there's no evidence that the speaker who's complaining of their Article 10 rights being interfered with is going to somehow actively incite violence or something like that. So we turn to, so having dealt with that point, we turn to the President's reasoning to his conclusion on the balancing exercise.
Sorry, just before you move on from the AM and News Corp and Green Corns case, I just wanted to check how you say the positive obligation on the court is invoked. Is it that I think you said it was an NGO in
Yes.
Green Corns, just calls the attention of the court to its obligation under Section 6, and that's all that is required. Is that what you're saying? Because the NGO wasn't itself a victim, I don't think you were saying, or were you saying that somehow it was a victim?
I'm not sure it was an NGO. I may be wrong. It may be a commercial company that provides care home services, but
right.
Does it under the statutory obligation? It's discharging the statutory obligations of public authorities in doing that. I think there were particulars of claim. There were a variety of claims put forward. But the one that found favour with Mr. Justice Tugendhat, who said, well, it's not confidential information. You could obtain it, for example, on a freedom of information request or something like that. There have to be planning applications and so on and so forth. So there are other ways to find the information. It will end up in the public domain. And the homes that have already been built and are established that they were concerned about were self-identifiable as homes for troubled children. So that there wasn't really a cause of action visible for the claimants, but they prayed in aid the harm that would be done to the running of the homes, and in particular the Article 8 rights of the children and carers, if it led to protests outside the homes.
The way, if one goes to page 2346, paragraph 51 of the judgment, Justice Tugendhat makes it clear that the point wasn't argued. That appears in paragraph 52, but he comments on it. He says that the fact that the applicant is a company and that no individual is named as a claimant requires comment. The courts recognise that institutions can be proper claimants, and refers to Ashworth. In that case, the defendant did not dispute that the hospital authority had an independent right in the confidentiality of their patients' records. So they could assert the confidentiality of the records as against the Article 10 rights being asserted by the media, by the media company.
Yes. I mean, medical records are slightly more complicated because there's a more direct link to the work of the special hospital. But in each case, they were asserting, in support of the case for an injunction, the individual Article 8 rights of patients, or in the case of Green Corns, of the children at the home.
I'm not sure of that. Without checking, I'm not sure. But I'm not sure that that's true of Ashworth. I think Ashworth may have been an Article 10 case where confidentiality was being relied on under Article 10 too.
Oh yes, I can see that point. Ashworth was a case about establishing an overriding public interest for interfering with the journalist's right to protect.
So it's not a case where the institution is itself relying on convention rights. Rather, it was defending it. It was asserting its the confidentiality of its own records,
yes,
as against the convention rights being asserted by the media.
Yes, and the public interest in it being able to get to override the source protection rights.
Yeah.
Yes, absolutely. But greencorns is in a different category. Greencorns is not the same. When the provider asserts the rights of the children and the carers.
Yeah. I'm not sure how far it takes us because the point wasn't argued. The judge refers to Ashworth as the relevant authority, but he doesn't explain how Ashworth would encompass the case in front of him.
No, our answer would again be the positive obligation that if he considered that the court had to act in that situation to protect the Article 8 rights of the carers and the children, then that was sufficient. So we're kind of back to the Section 7 point that the issue is before the court. The court reaches a view on the facts that it must act to protect those rights, and it can't not act because it would be acting unlawfully if it didn't act. I agree it wasn't argued in any great detail, but that seems to be implicitly what was happening in Greencorns. So the President's analysis is of the Article 10 rights is at 98 to 110 in the judgment. So we're on 344.
Thank you.
And it's in a section headed the Parents' Article 10 and Article 8 rights. And just to make the point that the parents asserted their Article 8 right to tell their story, which is a recognised right under Article 8 in our law, following a case called Angela Roddy, which is in the bundle at 3113. It's the same speech. It's the same Article 10 speech.
So what page number for Angela Roddy?
3113. It was a young girl who was subject to an injunction and then when she was older, wanted to tell her story through an article in the Mail. And she asserted rights under Article 10 and Article 8 on the basis that she was telling her own story of her own life. But the point is, you don't double up the right by asserting it under both convention rights. You don't double the value of the right. And when we see these cases come into Strasbourg, they will deal with them under Article 10 in recognition that the content of the speech right includes that right to tell one's own story, which is obviously an Article 10 right as well. So it doesn't double the value of the right. It's just a different way of putting the same right. And they would usually deal with it in Strasbourg under Article 10 as the primary right.
Have they ever dealt with it under Article 8? Mm-hmm. Have they ever dealt with it under...
I don't know a single case where they've dealt with somebody speaking about their own circumstance. Yeah. They will often say at the end of the judgment there's also an application under Article 8, but it's covered in the Article 10 reasoning because it's the same set of facts. So on the Article 10 side, the key feature of the President's reasoning was the lack of any specificity. This is at 102. This is the point we discussed earlier. In either case, regarding the substance of the allegations they wish to make or the identity of those they wish to name in doing so. And he considered this weakened the Article 10 rights they were asserting. We say he was right to do so. This is not just because Res requires the rights to be assessed at the first stage in specifics, although it does. There are important principles of Article 10 and Article 8 law here, which we'll mention next. But first, to repeat, these had led us to ask the parents to indicate in their evidence on the discharge applications which clinicians they wanted to criticise and in relation to which aspects of their work. And the references in the bundle to the correspondence where you'll see the refusals that we received are at 1740 to 1747. I won't take you to them, but you can see specific questions were asked and not answered. Also, this had led at a directions hearing on the parents' discharge applications to the President offering them that fact-finding hearing, where allegations against particular clinicians could be identified and considered. But the parents declined that, arguing that it was not necessary. And I'll just give you the references in the judgment on that point. Paragraph 48 at 332, paragraph 103 at 344. So the evidence was left in general terms without any fact-finding as to particular allegations or particular clinicians. So I said I would address the important principles of Article 10 and Article 8 law. It's perhaps easiest to get these from the Grand Chamber judgment in Axel Springer versus Germany, in which the Strasbourg court set out the matters that should be considered in an Article 8 versus 10 balancing exercise. The case concerned decisions of the German courts in relation to the Article 8 rights of an actor and his arrest for criminal offences, which the press wanted to report. The case is probably very familiar to this court. It was considered in Bloomberg recently. So we can go straight to the key paragraphs, which start at 3606, 3606 in Volume 3. The two most important criteria are at paragraphs 90 and 91, and as I say, these are very familiar. The first one, which is at the first sentence of paragraph 90, is extremely familiar. Will the expression contribute to a debate of public importance? That has to be read with paragraph 91, which is the second criteria, which is the role or function of the person concerned and the nature of the activities that are going to be spoken about. And then at 92 in the list of considerations, you need to look at, or you may need to look at, that person's prior conduct, and at 93, the truth, described as the veracity of what is going to be said about them. So these are very general considerations that apply in balancing Article 8 and 10. How do they affect the Article 8 right? How do they affect the Article 10 right? Obviously, the first and most important question is how does this speech about this person, this is paragraphs 90 and 91, contribute to a public discussion, to a discussion of general public importance? It's a point that often arises in the context of court reporting, which in general terms is of high public importance. But to make the point, we referred in our case to Lord Sumption's observation in Cuja, paragraph 30, and I'll give you the reference, it's page 2520 in the bundle, that published reference in a court report to a particular person as having figured or featured in the court proceedings may be wholly marginal, I think is the phrase he used, may be wholly marginal to the public interest engaged by the court report. So it's not enough just to say, well, the general topic is of public interest. You have to show that the naming of that person contributes to the public interest in the reporting. And we looked earlier on at Lord Roger in GNML, also a court reporting case at 75. I won't turn it up again, it's 3044. On the opposite possibility, which you remember he said publication of M's identity would make a material contribution to a debate of general interest, namely the freezing orders and the litigation about the freezing orders. So there's a spectrum. You can get names coming up that don't contribute and names that do contribute. And the same issue arises in any case where, in general terms, the topic of the speech is of public interest. So one way in which this was the point that we were discussing before lunch, in particular, my Lord Briggs. One way in which the role may come into play is where the person to be discussed in public is discharging public functions. And particularly relevant in this case is that line of authorities in Strasbourg under Article 10, where the person whose rights in issue, or the person who's being criticised and attacked, is what Strasbourg calls a civil servant, which is a bit of an omnibus term to cover anybody who does work in the public sector. And there's a well-known Strasbourg principle in Article 10 law that the state may need to protect civil servants against public attacks calculated to affect them in the performance of their duties and to damage public confidence in them. And we've cited Busoiok versus Moldova at 3629 in Authorities Volume Tab 3. At paragraph 64 on this principle.
64?
Paragraph 64.
Yeah.
This is a regurgitation, if you like, of standard formulation in Strasbourg in these cases. And it's the first half that's important. The line begins in a case called Janowski versus Poland, which was a police officer being attacked by an individual member of the public. But there are other cases in the line. What the court said in this case was that the civil servants who were working at an airport in Chisinau in Moldova, which was a publicly funded airport, but they weren't really in the position of police officers or prosecutors or somebody in whom public confidence and trust particularly needed to reside, they didn't benefit from this principle.
The allegation was that they were selling planes that were undervalued. Yes.
Yes, in which there would be a strong Article 10 right and no particular reason to protect them against the allegation and the identification. But for present purposes, our point on this pretty clear line of authority and formulation is that in order to...
Can I just ask you, Paul, is this an Article 8 contest with Article 10 in this particular case?
No.
Or is it simply that the public interest in protecting civil servants from obloquy was a proper justifying factor to resist an Article 10 complaint?
Yes. Where there's a complaint of Article 10 violation, for example, in defamation, the court will look at the public interest in protecting certain civil servants. I mean, there are many cases on this, and I haven't gone into the ones about judges, of which there are many, but the Strasbourg Court also takes a position on public criticism of judges and naming of judges. As ever, the facts are everything, but our point is there is a recognition of the need to focus in on what the person is doing, what the role is, and why you may need greater protection for your reputation and your status from attacks under Article 10. And it would apply equally in this Article 8, Article 10 balancing case that we're looking at here. So we say it's not enough for the respondents to say, well, they're all clinicians working at National Health Service hospitals. As I said earlier, I mean, a senior consultant with public-facing duties who had treated a child would be in a completely different position to a junior nurse or a midwife in a maternity unit. So you need to know who's being attacked and how they're being attacked. And if we look at the judgment of the President, he clearly thought, if we look at paragraph 33, page 327, that it was important to establish these facts here, where the staff concerned were working in a paediatric intensive care unit, one might say, quintessentially a private space in a hospital, you know, a closed and private space in a hospital, in which medical ethics and confidentiality in the interests of children are engaged. And we would say that's clearly so here. You have to look at the unit, you have to look at the person working in the unit, what they're doing and what the criticism is of them to assess the public interest value of the speech. Doesn't follow...
Inevitably, the fact that they're doctors working in the hospital doesn't give them any sort of immunity from justifiable public debate. I mean, for example, the Haastrup clinic has been the subject of great debate, and you know, if there is something properly, if there's a matter that's actually of public significance, then what's wrong with that?
Well, the question is naming an individual clinician in connection with a particular criticism. I mean, there are different...
You get into what's in a name point, don't you?
Yeah, I'm going to come on to that in a moment. That is absolutely the point, but it's not equally... I'm not arguing for an immunity. The Lord says that there's not an immunity for those people. I'm not arguing for an immunity. Equally, there is no blanket right to name anybody. The media often don't name people in connection with reports of that sort. I mean, you might just as well ask how many individual clinicians of a junior ranking in that public debate about that unit and that hospital have been named in the media.
And if you think about a slightly different scenario, if you think about social work and the public debate, well, the public concern that there sometimes is over whether children have not been taken into care when they ought to have been, or have been put into placements that they haven't been put into. Those decisions may be taken by relatively junior members of staff, but nonetheless, the media would expect to be able to name them in order to bring the story to life and maintain public interest in them.
Well, I'm not sure it's that simple. In that case, the issue is how much power and influence does that social worker have over what happens to the child? So the argument there is it's material to name the social worker because they may have taken a life-changing decision for the child. And that's exactly what we're arguing here. There will be, in the group of clinicians, there will be some who are more obviously in that category and some who clearly aren't in that category. And without knowing who they are, you can't evaluate the right. I mean, it's a very simple point, but you have to have the specifics of which Lord Steyn spoke.
And how do you maintain coherence insofar as if you look at it from the point of view of defamation, you can say whatever you want. You will not get an injunction to prevent publication if the person who wishes to publish says, I'm going to prove it's true. And the additional factor in this case is the harassment. It's not the publication of allegations, it's the harassment that comes as a result of it. And so there's if people wish to criticize the treatment they receive, why can't they?
Well, on
unless
the first,
there's harassment following on.
Yes, exactly. I mean, on the first point, I think the answer to that is in Cuja, which I'm not sure I have time. It's a point in Cuja that I'm not sure I have time to go to, but that very point comes up in Cuja in the judgment of Lord Sumption, that you couldn't get a defamation injunction.
Yes.
But if you can engage the Article 8 privacy right, different considerations arise, and you can use Article 8 to get an injunction. And that's simply the state of the law as it is in this country at the moment. But if it's pure defamation without an appropriate case under Article 8, you can't get the injunctive relief. So the basis of the claim here is, as I said, impact, intrusion and distress, the potential for impact, as the President put it, if the names are published, and in particular if there's criticism online. It's a different formulation of a claim. It's a different type of claim. It's not pure defamation. It's formulate.
Can I just unpick that last sentence of paragraph 33, where he says, and in particular the activity on the PICU, which is of its nature private. It's obviously private in the sense that there's a patient in there. But it's obviously private in the sense that there's a patient there being cared for, and one can well understand why publicity about the conduct in court of an application, a best interest application, where somebody's in hospital still undergoing active care, readily attracts that person's privacy rights, which would have been the situation when these orders were originally granted. But once the patient, the subject of that care, has sadly died and passed away, what's left of the privacy, insofar as it has legal consequences, that normally surrounds the activities of the PICU?
Well, it's not the privacy of the patient, it's the rights of the person, of the worker in that context, whether they have a reasonable expectation that their day-to-day work will be protected to a degree as private because of the nature of the work.
But it's not just because they're caring for a patient. It's not their own right to privacy, it's the patient's right to privacy, isn't it?
No, absolutely. Their right is to be protected against the intrusion and distress that would follow from the name being published and the material appearing on the internet. But I think this is all part of my same point, that if you're a nurse, for example,
yes,
junior nurse working in the PICU, in those circumstances, you're not in the same position as the clinical director, consultant clinical director, who happens to have treated the child, who has a public-facing role. Your role is entirely different. Your role is much more limited. It occurs in an intensely private setting. There's no public-facing aspect to it. That has to be relevant to your privacy rights, and whether this sort of criticism can be made of you with you being named publicly. That's the point. But the point at the moment is the President, I mean, you're either for us or against us on this, but our point was you can't do it on a blanket basis, and the President accepted that. You can't simply say that just because somebody is a clinician at an NHS hospital in those circumstances, you can say anything you want about them with any consequences. There may be different people may be in different positions, and in order to assess what form an injunction should take and who should be covered by it, you would need to know who's going to be spoken about and what's going to be said about them to be able to evaluate the strength of the Article 8 and Article 10 rights.
I apologise for interrupting, but if the parents had taken up the President's offer of a fact-finding hearing, one would have gone into all the detail about whether the complaints were right or wrong, or whether there was a public interest in them, or whatever. Is that right?
Yes. I mean,
it's a major bit of litigation.
Possibly not. I mean, it wasn't for us to say, but the President was concerned to know what allegations are going to be made against who, in order that he could decide on the need or otherwise to discharge the injunctions. And you can see he's referred to in the judgment various allegations that he understands have been made in the past. I think he wanted some certainty about that, and it's appropriate in Article 10 and Article 8 law to go to a degree of specificity about that. I mean, I can see you can say, well, fact-finding hearing may have been overblown, but we just don't know. We just don't know what the parents would have focused on in terms of what they wanted to criticise. On the veracity issue, we've cited the well-known observation of Lord Hobhouse in Reynolds versus Times to the effect that no public interest is served by communicating misinformation about people. Probably don't need to look at that, it's very well known. It's at 2903 at page 263A in the report. But it's probably also worth going back and looking at that part of the reasoning of Mrs. Justice Leven in the Manchester University case at paragraph 45, which we took in earlier. It's at page 2664. in the first two sentences.
Did you say 3664?
2664.
Oh, thank you. Yeah.
She says, it is in my view difficult to see why either open justice or the public interest is harmed, save to a minimal degree, by the anonymisation of the treating professionals. This is not a medical negligence case, and although the father has made allegations about the treatment, these are not substantiated by evidence and not pursued by Mr. Quintavalle. So she was intuitively, perhaps, looking to see whether the allegations against the clinicians that were going to be made if the order was lifted were substantiated and how they would add to the public interest. And we say she was correct to do so. I mean, one of the problems in this case, obviously, is that she had the benefit of the full end-of-life hearing. So she'd heard the witnesses and heard the evidence and could form some sort of view about the allegations the parents said they wanted to make on lifting the injunction. This wasn't possible in Abbasi because there hadn't been a full hearing, so the allegations hadn't been considered. They had in Haastrup. So we say the President's approach in considering how the lack of specific evidence weakened the Article 10 rights here was correct and certainly not wrong. What did the Court of Appeal say? Well, they didn't say he had misdirected himself on this point, these points. There's a section at 104 to 111 in the judgment, at 306, pages 306 to 307, where they deal with this part of the reasoning. But it's fair to say they don't deal with any of the law that I've just addressed as to why it might be important in the way the President considered to establish what the allegations were and whether they were true or not. They said at the end of 105, the point that this is our point that he needed to know what was going to be said about who. The point travels no further than if a person comes to court and speaks in general terms of Article 10 rights, when there are powerful qualified rights on the other side of the balance, the Article 10 rights may not weigh very heavily. No authority is cited for that proposition, and we'd respectfully suggest it's wrong and illogical. The strength of the Article 10 rights fall to be assessed in their own terms by reference to what the Speaker wants to say about particular individuals whose Article 8 rights will be engaged. The weight to be ascribed to the Article 8 rights in play the weight to be ascribed to the Article 10 rights in play doesn't depend on the strength of the Article 8 rights. You have to look at them in isolation according to the principles that we've discussed. And the Court of Appeal then went on at 106 in the Abbasi case and 109 in the Haastrup case to disagree with the President's conclusion that there was a lack of specificity in the evidence of the parents about what they wished to say. And in each of these paragraphs, they listed general topics that the evidence suggested the parents would want to discuss publicly. So putting aside for a moment whether an appeal court can simply disagree with the specialist judge at first instance about this, we would suggest these paragraphs miss the point on the basis of the analysis that I've put forward. So to take two examples in these lists of topics, very relevant to the balancing exercise in this case. Regarding the decision in each case to apply for a declaration that treatment could be withdrawn when the clinicians decided it should be, saying publicly that a particular doctor gave a child a death sentence or was trying to save the NHS money would be untrue, or at any rate unless proved true, and we would suggest irresponsible. There would be a weaker Article 10 right to say that sort of thing, even though the wider issue of why the declarations were sought is of public importance. And then regarding the circumstances surrounding Isaiah's last day of life, if what was to be said, which is 1093, if what was to be said was that particular nurses appeared to take joy at the prospect of Isaiah dying, that would be low-value speech because it would be untrue, at any rate, until proved true, and would be irresponsible and damaging. So it's not enough just to list general topics. You've got to look at what is going to be said about whom. And finally, on the point about what's in a name, which the Court of Appeal deals with at 111, it may be important to name people, and we just discussed this point a moment ago, it may be important to name people in media reports where there's a general discussion of is on a matter of public interest. That's not contentious. Though often the media do not do that if there's insufficient factual basis, or it would be valueless or irresponsible. But what the President was concerned about was something different, as we've seen, which was publications of allegations against named clinicians as part of a set of personal grievances of the parents, covering their experiences in dealing with the clinicians. And we do simply say the court doing the balancing exercise can't simply accept that it's important to name anyone in connection with any allegation or criticism. On the Article 8 side, the President rejected the main argument of the parents as to why the case was weak and unsustainable. That was the Ward argument. And he relied on the Garden-Evans cases at 106 in his judgment, page 345, as having demonstrated what he called the potential for attacks on clinicians in these cases. And he concluded that in 2021 this was a more serious risk or concern than at the time of Ward. The evidence about these cases was in the bundle before him. And if I could just refer to a couple of passages at 1133, which I think is in Core Volume 2, there was, which concerned the Charlie Gard case at Great Ormond Street. There was evidence that the trust chair at Great Ormond Street had complained of thousands of abusive messages, including death threats, being sent to clinicians at the hospital. And a public statement was made to that effect because of the concern of the hospital. It's at the top of 1133. As I say, including death threats. At 1120, in the Alfie Evans case at Alder Hey, the media reported the chair and chief executive of the trust saying there'd been a social media storm that had included many untrue statements about our work and the motivations of our staff. And further on in the same article at 1124, that staff at Alder Hey had received in person via phone calls, email, and through social media channels a barrage of highly abusive and threatening language and behaviour that has shocked us all. As a matter of fact, I should point out that the parents didn't argue that there was no potential for clinicians to become vulnerable to online attacks if the injunctions were lifted and the clinicians were named. So they didn't, in front of the President, engage in the sort of detailed forensic analysis that the Court of Appeal engaged in on the question of risk. As I've said, their case was very different. It was in effect that Ward precluded the injunction. As a matter of law, we've touched on this, it's obviously important to identify the aspects of Article 8 that are in play in this case. It is the right to informational privacy, specifically the right to protect one's personal identity in a particular context where it may be harmful to you if it's published. This often gets referred to in the cases as a right to anonymity, and this aspect of the Article 8 right is well acknowledged in Strasbourg by reference to the right to protect one's name, and I'll just mention Pfeiffer versus Austria, paragraph 33, at page 4186, and also it's referred to again in Axel Springer, at paragraph 83, page 3602. So it's a well-established strand of the Strasbourg Article 8 jurisprudence. It was also in play, as I've said, in the PGS versus NGN case in this court. The facts were very different. That was a story of sexual infidelity, but the point was the same. It had been published in this jurisdiction, but without those concerned being named. So what they were seeking to prevent was being named in connection with the story that had been published and the allegations that had been made. And you may recall the story had been published throughout the world, in Scotland and elsewhere. So the injunction was about naming them in this jurisdiction. And the issue was about lifting the injunction to name them. So there was a parallel. Paragraph 35, as I've said, Lord Mance spoke of the intrusiveness and distress that can result from being named through an anonymity injunction being lifted.
My recollection of the case is that the names of those involved were very widely known because they'd been published on the internet. And what concerned the court rather was that over and above the naming which already taken place, if the matter was if they were going to be identified in the British media, there would have been the whole media circus around our home, helicopters overhead, and all that type of physical intrusion on their private lives, which could be prevented, and which was something that didn't result from the internet publication.
And could be
prevented by an injunction.
By not allowing them to be named in this country.
Yeah.
Yeah. Lifting the anonymisation injunction would have named them. So I'm not saying it's comparable on the facts, but the right in issue is the same and the structure of the case is the same. But the court was concerned about the impact on the private and family life of the family.
Yes. Another thing is it was a rather different case because the names of the people involved were already, as it were, water under the bridge.
Oh yes, it was a very different case from that point of view. I'm not sure that really helped us in the case, but from that. But all I'm saying is the structure of the case is the same, there was discussion. You can see this at paragraph 41 in the speech of Lord Mance.
I'm sorry, which page?
2735.
Thank you.
That there was some discussion about the effectiveness of injunctions as remedies in this case. Especially the first 5 lines at 41, that if there is a concerning invasion of privacy, causing intrusion and distress through somebody's name being put into the public domain in a particular context, this may not be remedied effectively if the injunction is lifted and the person is left to pursue other remedies based on publication of their identity, like defamation damages and so on, so forth. So it's that line of authority in Strasbourg about the need for a practical and effective remedy in domestic law to protect the Article 8 right where it needs to be protected. And very often that is the injunction and the effect of the injunction. And the effect of the injunction in closing down the exposure to that sort of intrusion and the potential for that sort of intrusion. Then you lift it and the circumstances change completely. That's the point that's being made, and you can't really get that back. You can't reclaim the harm and damage that's been done in those circumstances if the injunction is lifted. So again, there's a comparison with this case. So as not being made vulnerable to these consequences through naming, these potential consequences, which the President speaks of. I mean, this is clearly a key difference between the President and the Court of Appeal. The President did not consider, I suppose here in a sense we're at the nub of the case, the President did not consider in all the circumstances that the risk of these consequences, if the injunction was lifted, should be taken in all the circumstances. So lifting could not be justified. And he didn't engage in the sort of what I've called the forensic analysis of the Court of Appeal about the degree of risk on the facts of these cases if the injunction was lifted, which I'll come to in a moment. And we say he was right in this. At very least, he was entitled to take this approach in all the circumstances on the facts. The fact is, if the injunctions are lifted, and he could see this, and this consequence ensues, this happens, the horse will indeed, to use Mrs. Justice Leaven's words in the Meek, well and truly have bolted. I mean, that is it. The clinicians will be fair game online, and the harm will have been done. And there's nothing that realistically they could do to resolve that situation. We've discussed this before. They just simply couldn't commence actions, afford to find the anonymous actors, and so on and so forth. It's just not realistic to expect that to happen. So the President was clearly very concerned about that. So so we say the President was right about that. In our last section, we deal with the Court of Appeals. I said the third thing I would deal with is the Court of Appeals judgment and what we've characterised as the 4 self-directions. In our grounds of appeal, we identified 4 issues on which the Court of Appeal gave its self-directions, leading to the overturning of the President's decision, each of which seemed to us to be wrong and to raise issues of general importance. As in our case, we'll address the self-directions in a slightly different order to the way in which they were identified and discussed in the permission application, because it seems to us the most important one is what we've called the generic evidence issue, and then secondly, the risk issue. Where this goes is a matter for the court, obviously it'll be a matter for this court, whether it agrees that some or all of these directions were misdirections, and if so, what the consequence should be. But our case is that the President's judgment was not wrong in the round, in the sense that it could be overturned in the Court of Appeal, nor were there errors of principle in the President's reasoning, which might have had the same consequence. And our position is this appeal should be allowed and the President's decision and reasoning should stand. The generic evidence issue arises because of the observation by the Court of Appeal, which you see most pointedly at paragraph 125 on page 310, that there was evidence within the trust's evidence, which one might call non-hospital or non-clinician specific evidence, and that it pointed to particular concerns which the Court of Appeal described as the core concerns, paragraph 125, being that naming clinicians might undermine morale, make it more difficult to recruit into the speciality, and increase pressure on staff and hospitals. The concerns identified in paragraph 30 of the President's judgment, particularly at Roman 4 and Roman 7, seem to us rather more than about undermining morale. They're about proper clinical treatment of very sick children and the ability of the clinicians to do that, which is pretty important. But we'd accept that this is a sort of rolled up complaint about the evidence, and something of a catch-all. But it is important to capture the concerns identified by the President that naming would have a detrimental consequence for the care of the children and would inhibit, this is an important point, decision-making in end-of-life cases. It's often referred to as the defensive decision-making point, that if clinicians are liable to be identified in these cases, they may get defensive in their decision-making for fear of being criticised later on. The issue for present purposes is, did the President err in principle by taking into account in some way on the balancing exercise evidence that he should not have taken into account? And that depends on what the law is regarding evidence or considerations that a first instance judge can take into account when doing the parallel analysis on the facts. It is trite law, as the President observed, that in a negative interference case, where the state, not an Article 8, Article 10 balance, but a negative, where the state is interfering with the right, whether it's the Article 8 or the Article 10 right, under Article 8.2 or 10.2, when you seek to justify as the state the interference by reference to a legitimate aim, you can put in a body of evidence saying, look, this is the public interest issue that's at stake here. You can do it, and it's done routinely. It's the basis of most justifications under Article 8 and Article 10.2. There is a societal reason for this interference with the right. And the President, of course, said, well, if you can do that in a vertical application case, why can't you look at that sort of evidence in a horizontal application case? We would suggest the courts have done this in balancing cases. There are examples of where the courts do it without almost seeming to think about it, although the Court of Appeal criticised the President for doing it in this case.
I mean, obviously, the point I was trying to make to you earlier, that when you've got a balance, Article 8, Article 10, Article 8 has Article 8.2 beside it, and Article 10 has Article 10.2 beside it.
Exactly.
And you look at the rights in the round, including the public interest that weighs against the individual right.
Exactly. And
Strasbourg's usual practice of examining the application under one article, and then when it comes to the other one, saying that the analysis under article, the alternative article, adds nothing to the analysis, or words to that effect.
Yes. But what's happening in Lord Staines's parallel analysis is, because it's not a vertical case, those parallel considerations are arising in each case. Should I interfere with Article 8? Should I interfere with Article 10 in the way sought? But that element of the consideration is merged into that single stage of
Just Lord Staines's third point, I had construed it perhaps wrongly as saying that when you're weighing up what one article is offering, you look at the justifications for interference and so on within the article itself, as well as in a question of balance.
Yes, but the justification under Article 10.2 will be the rights of others at the first stage, so it'll be the Article 10 rights of others.
Well, not necessarily just that.
Not necessarily.
There are other legitimate aims as well, which may come into play.
Absolutely, absolutely. Which, of course, opens up a broader canvas of the sort of evidence you might put in and what you might look at. But I think the Court of Appeal's objection was that this was not purely about the Article 8 rights of the individual clinicians.
Yeah.
And in the Greencorns case, which we looked at, and I'm just pointing out that judges have done this. I mean, one judge who did it was Mrs. Justice Leven in the M case, which we've looked at now numerous times. Paragraph 12, page 2663, where she does this quite straightforwardly in the first couple of lines. She says, look, there are the Article 8 rights of the individuals, and then there are these public interest considerations in relation to the functioning of the service and the work of the doctors and their clinicians, and their ability to do the work without being affected in this way. So it doesn't seem to have occurred to her that you couldn't take into account those sort of public interest considerations. And in the Greencorns case, which we looked at a moment ago, there was an interesting wrinkle in that a number of the homes hadn't yet been set up by the provider. So they were prospective homes. And so there were no children or carers there at those addresses yet, whose Article 8 rights arguably were in play. And so if you look at page 2355 to 6, in Greencorns, you'll see the judge taking into account in favour of the injunction the general public interest in providers, whether state or private, of this sort of facility, of being able to give safe and secure homes to troubled children on an ongoing basis. So the future public interest concerns, if you like, if addresses could be published and future provision jeopardised by those being published. So there's no Article 8 right in play there at that point. There are no homes. But he's still bringing into the balancing exercise on the injunction an important public interest consideration, which is if you start publishing the addresses of the homes that are about to be set up, that will affect the service and the ability to provide the service. We also say the reasoning in the Bloomberg versus ZXC case supports this. The court will remember Bloomberg. It's been decided relatively recently. ZXC ran a misuse of private information claim when the publisher published information from a confidential letter of request to a foreign state in an investigation into him by a law enforcement agency. So his Article 8 rights had to be balanced against the publisher's Article 10 rights to publish the information. And if you turn to 3518 in Volume 3, towards the paragraph 29, you'll see the reasoning of the judge at first instance took as its starting point that there was a very clear public interest that the contents of the letter of request should not be published, and that the confidentiality of the law enforcement agency's investigation should be maintained. And then if you look at 3546, so the concern was that publishing that type of information could damage those investigations and the letter of request procedure.
Which paragraph?
3546, paragraphs 152 to 154. This court considered that reasoning because there was a challenge to it in the appeal, and said, this is the judgment of my Lord Stevens and Lord Hamlin, which was the judgment of the court. And stage 2, that's the balancing stage, the judge was right to place reliance on the public interest in the observance of duties of confidence when carrying out the balancing exercise. And then at 153, this is, I think, Lord Hodges' point, that public interest both weakens the justification for interfering with or restricting the right of privacy and strengthens the justification for interfering with or restricting the right to freedom of expression. It's also relevant to the proportionality of such interference or restriction. In the present case at 154, there is a general public interest in the observance of duties of confidence and a specific public interest in maintaining the confidence of this letter of request. So the court is there identifying the relevance of public interest considerations at those two stages in the balancing exercise, and it seems to us that's what the President had done. And the issue of law really then is, well, not is it precluded, is it impossible to look at that evidence, but what's the relevance of that evidence and what weight do you give it? And this is, after all, an injunction. It's an equitable jurisdiction. What would you do, for example, if at the first stage or the second stage, the Article 8 and 10 rights were completely evenly balanced? How would you decide what to do? Could you look at public interest considerations then? There is no authority that we know of that supports the Court of Appeal's analysis on this point. The Respondent's case on this point seems to be that the concerns in that body of evidence referred to by the the President are merely what it calls administrative concerns. But we don't accept that characterization, and we would suggest the relevance of the weight and evidence was a matter for the President. He clearly thought it was very important. The Court of Appeal at page 310, paragraph 125, also seemed to be directing itself, this is the Uller point, seemed to be directing itself that to allow concerns of this sort identified in what the Court of Appeal called the generic evidence to justify restricting speech would breach, I think they say, 125, the domestic court would be finding a principle which has not yet emerged in Strasbourg and would be breaching the Uller principle. And it's not clear what role that point or that conclusion in the Court of Appeal's judgment plays in its analysis, its criticism of the President's reasoning. It's not clear whether they're saying he shouldn't have taken this evidence into account at all.
They seem to say that at one stage in the judgment, that it shouldn't have been taken into account at all.
Yes.
And then equivocate later on, saying that if it was to be taken into account, it carried little weight.
Yes, which is rather...
It strikes me that when you read in paragraph 125, line 7, I think it is, after reference to Article 10.2, they say that term, this is public safety. I mean, it's a straw man. That term is linked in the article and in the case law. If interference is justified on grounds of, and then following the wording of Article 10.2, national security, territorial integrity, and the prevention of disorder and crime. But if you read on in Article 10.2, the next one is the protection of health.
Yeah. Yes. And the protection of the rights of
others.
Yeah.
Which are really the two legitimate aims centrally in play here when it comes to justice.
Well, that was really the point I'd been making. You read down 10, you read the 10.1 right, but against the limitations in 10.2.
Yes.
And what goes into the balance.
Yes.
Is the right so limited?
And there has to be some evidence to support the concern of underlying the legitimate aim that's being pursued. But then they say at the end, the domestic court should not run ahead of Strasbourg in finding a principle in the convention which has emerged in Strasbourg. But we would say there's no breach of the Uller principle here. It's too well known to take you to it. It's Lord Bingham's opinion in Ulla deals with this at paragraph 20. It's at page 3187. And the important point at page 3187, which is at C to D in that paragraph on the side notes, is this: what a domestic court shouldn't do is interpret the convention in a way that gives rights more generous than those identified in the Strasbourg case law. But the President taking account of the generic evidence in the balancing exercise didn't involve interpretation of the convention. All the issues of interpretation and principle under the convention about whether the positive obligation to protect Article 8 rights might require a state intervention, even though they restrict free speech, were settled in von Hanover. That was the interpretive exercise. So a domestic court taking into account particular considerations or evidence on the balancing exercise doesn't involve interpretation of the convention. And that was a clear misdirection as well. Secondly, there's the risk...
You don't have to go to von Hanover, you just go to Article 10.2.
Yes. Yes, and understand how the Lord Staines parallel analysis works. It's a question of evidence and facts, not interpretation of the convention. The risk direction, it's not clear exactly what the Court of Appeal was looking at on this. There is a paragraph 82, page 302, where the court is at the first stage, or concerned about the first stage, the balancing of Article 8 and Article 10 rights, the comparative importance of the two rights in play on the facts of the case, because they seem to want here to drill down into what the Article 8 rights are, and this starts the run of paragraphs that deal with the risk self-direction. The following paragraphs deal with it. So the Court of Appeal here is purporting to identify the Article 8 rights in play, and we obviously got no quibble with the suggestion that Article 8 can protect against damage to personal reputation, and that's an aspect of Article 8. But this right, this aspect of the right is secondary, we would say in this case, to the right to prevent publicity about their identity, which is the right we discussed a moment ago. Simply because if the person's not identified, there's no damage to reputation. So the primary right in issue here was the right of anonymity. And the problem with paragraph 84 is it's not identifying or characterising the rights in play properly. It's identifying the consequences about which there's concern if the injunctions are listed, but these are not the rights which they're supposed to be evaluating comparatively. And we would respectfully suggest this leads the Court of Appeal in the paragraphs that follow, being 85 through to 92, into a rather complicated exercise about how a judge might go about assessing the degree of risk in a case like this, and most importantly, to inject into the assessment of the comparative importance of the rights in play, the need to assess the risk of harmful consequences materialising at being at a particular level, i.e. very high or not very high, in order for the right to have any weight, for it to be of comparative importance. And they reasoned to that conclusion, what I've called their sort of forensic analysis of risk, by reference to other areas of the law. So we can see at 86 they considered the level of risk of torture that's required to be proved in convention law and how it should be assessed in a challenge to extradition or removal under Article 3. And then they considered a claim to anonymity for a police officer in a public inquiry. That's the officer L case and the Bloody Sunday inquiry, in which the Article 3 right is...
Article 2.
Article 2, I'm not sure Article 2 and Article 3, asserted by an officer who's seeking to be anonymised in the inquiry. And then thirdly, they looked in some detail at how risks are assessed for a child in family cases concerning care and placement orders. That's 89.
But the general proposition is that both the rights neither right has priority, but there must be recognised factual circumstances without changing the legal test, where the nature of the rights in play require slightly more evidence than in other circumstances. And open justice and public debate on important issues surrounding end of life are one such example. Insofar as the language used by the Court of Appeal goes, might suggest there's a change in the legal test, that's one thing. But the realities, the practical realities, surely are that in certain circumstances you need to have a slightly more convincing case than in other circumstances.
Well, there's no doubt about that.
Yeah,
The facts
right.
and the evidence are everything.
And the respondents say this is such a case.
Yes, but at the moment I'm looking at the way the Court of Appeal reasoned, and they seem to have reasoned through to some sort of required threshold for the Article 8 right to have any...
But the analysis, what's wrong with Lord Justice Jackson's analysis, and that is when you're looking at the risk to Article 8, why don't you actually have a look to see how likely the consequences might be? And then what the consequence, how likely is it to happen, and what are the likely consequences? What's wrong with that?
Well, there's nothing wrong with it per se, but this is a difficult case from that point of view, because the identities have been protected for a long time by the injunctions. So it's very difficult to say what will happen following this litigation if the injunction...
Then the Article 8 right is weakened, if you can't say.
Well, we don't agree with that. That's I think, the point of difference.
Well, I mean, after 20 years, after 30 years, you would be saying the same thing.
It's not a question, we would suggest, respectfully, it's not a question purely of time. It's a question of whether the potential exists and whether the consequences would be serious enough if they came to pass, and whether it's, as the President put it, whether it's worth taking the risk. That's the issue. If it's purely time, you get to a sort of mechanical analysis of the situation. You have to look at certainly the evidence and the facts, but you can't discount the Article 8 right altogether. I mean, the President thought it was a very weighty Article 8 right because of simply the potential for this to happen if the injunctions were lifted. You can't discount it altogether on this sort of basis, because that's not the way the balancing exercise works. We would respectfully suggest you can't sort of gloss it like this and say there has to be a particular threshold element of risk, or there has to be an element of risk sufficiently high for the right to have any weight. I mean, it may be that you feel the justification isn't strong enough, or that it's proportionate to interfere, but the right, I mean, they're looking, this is why I made the point, they're looking at this, it seems as this is why it's an error, they're looking at this in the evaluation of the right, which is the right of anonymity. They've confused the consequences with the right and the weight to be ascribed to the right and the importance of the right. I'm not disputing for a moment you don't look at the evidence and the facts on the later stages, justification, proportionality, which are less technical in balancing the two rights, but we don't. It seems to us they're looking at this at that stage of the balancing of the rights, and with respect, we don't think that's right. But it's rather a dry point, because we're looking at whether there's an error in the Court of Appeal's reasoning, and we appreciate that at the end of the day, this court, if it finds that the Court of Appeal did err and it wants to look again at the question, it will have its own thinking about this. But at the moment, we're just looking at whether the quality of the reasoning of the Court of Appeal and whether there were errors of law there, and it seems to us that was an error of law. Next, there's the compelling evidence.
You're founding on the evidence that we have seen from Charlie Gard and the Evans case to say, at least at the time of the decision making, there is a clear potential for acute interference with the private life of people who are making the decisions.
Yes.
The question then arises, I think Lord Stevens was hinting at it, and the President has raised the matter already, what happens with the passage of time.
Yes, but look, I don't... This is a very high-profile case. I mean, I don't want to argue a bootstraps point here because it's not technically relevant, but it is part of the concern of the trust that the case has a very high profile, and there may be consequences if the injunctions are lifted of the sort that we're concerned about. But I appreciate what we have to look at is the position when the President took his decision.
Yes.
But the difficulty is, and I'm repeating myself, with the coverage of the injunction, there's a kind of period of nothing happening, except that. But the question is, what are the consequences of the lifting of the injunction? And it's very difficult to produce, I mean, I think the trust's concern is it's very difficult to produce evidence of that. And was in 2020. It's not like, I mean, I think we said in the case, you know, in a quia timid injunction, you may have evidence, specific evidence, the identified defendants threatening a wrong. You can refer to that. We don't have that here, but the concern is still valid on the general evidence about the context. So the Court of Appeal reasoned at 76 to 79 that evidence of a compelling nature is needed to curtail the legitimate exercise of free speech in an Article 8 versus Article 10 balancing exercise. That's at page 300. No authority directly on point is cited for this proposition, which doesn't appear in any of the cases we referred to on the jurisdiction issue as a proposition of law, if it is a proposition of law. There's nothing to this effect in Re-S, in Re-BBC, GNML, or indeed A versus BBC. And we would observe the courts have been very careful not to add rules or glosses to the parallel analysis, to leave the facts to speak for themselves in individual cases. So if this was a gloss being added, we say it's wrong. It also seems to us that, and it seems to us that's what the Court of Appeal is doing here, and it would be a big development in Article 8 and Article 10 balancing if this were to be the law in our domestic jurisdiction, that you always had to produce compelling evidence. It would tie the hands of judges in these balancing exercises. And as you've seen, we question various steps in the reasoning. First of all, the passages at paragraph 76 in the Court of Appeal's judgment, page 300, a light on the use of the word compelling in different contexts in 3 of the balancing cases we've looked at, and it draws support from these for its proposition. But as we pointed out already by reference to GNML, paragraph 17 and 74, and Ward, paragraph 181, what the judges were doing in those cases was simply commenting on the evidence in that case. There's also an error in that in the passage in Re-BBC at 81, which is referred to at the end of 76 in the Court of Appeal's judgment, which is in the bundle at page 2065.
Well, before we leave it, one might observe that in 76, the references are Lord Roger speaking of compelling submissions.
Yes.
Sir James Munby in A and Ward speaking about evidence and arguments more compelling than they've put forward. BBC Lord Newberger speaking of compelling reasons. All of that is really unsurprising. One needs compelling reasons or compelling submissions, compelling arguments to justify an interference with freedom of speech. But in 77, it becomes, at the end of the second line, the use of a language of the need for compelling evidence. That's slightly different.
It's very different. It's very different.
That's not what was said in the earlier cases.
Correct. We agree with respect. I hadn't, prior to this case, appreciated quite how popular the word compelling is with judges when commenting on the balancing exercise. But it's in that many other places in the authorities. But it doesn't amount to a principle.
You don't need compelling evidence where the freedom of expression is to spread misinformation. I mean, you wouldn't have to have any compelling evidence to overcome that.
No, exactly. That's the whole point.
Or any compelling reasons, actually, frankly.
It's the whole point of the balance, isn't it? That it's relative. What is needed is relative, but you look closely at the two rights in play. And there are other things we take issue with. We don't. The reference at 77, page 301, to Handyside and Stoll is not contentious, but those are vertical cases. And really, what happens when you get to Strasbourg in the balancing exercises cases, which do go under 8 or 10, if you lose out in the balancing exercise, you go to Strasbourg as the loser under your right, 8 or 10. The Strasbourg approach is much more nuanced. What Strasbourg tends to look at is the reasoning of the domestic court. Is it relevant and sufficient? And within the margin of appreciation for the balancing exercise. These are vertical cases, Handyside and Stoll. I mean, there's no issue that as an abstract principle, obviously, the Handyside principles are fundamental, and the need for a convincing justification in a vertical case goes back to Barthold and Germany, goes back decades. They're not contentious principles, but they don't operate in the same way in a domestic balancing case. So we think that's wrong as well, and doesn't support the argument for compelling evidence being a principle. And then at 78, there's this self-direction that Lord Staines's indication that neither article has precedence over the other was an indication that evidence of a compelling nature is needed to curtail the legitimate exercise of free speech. Well, that's wrong. No authority is cited for it. And we'd respectfully suggest if that's what Lord Staine had intended to say, he would have said it in Ries. All those words signify in Ries is the two rights are presumptively of equal value, so there's no presumption in favour of one rather than the other. And the facts and circumstances of the individual case will have to be assessed in order to decide which should be restricted. Finally, the Court of Appeal also compared its proposition to Norris versus the principle in Norris versus US, which was a statutory appeal against an extradition decision. This is at 2666 in the bundle. I'm not sure it's necessary to refer to it, but the principle is, again, well established, that if you want to argue Article 8 to defeat an extradition request, it has to be an exceptionally serious Article 8 case. Otherwise, everybody would say, my private family life is being interfered with, please don't extradite me. But it doesn't tell you anything about what evidence is required on the balancing exercise.
It sometimes seems as if they do, actually.
Well, maybe they do, but it's being used here to get to a proposition that it simply doesn't support in this context. And then finally, there's a short point about the open justice, what we call the open justice direction. At 118, page 308, the Court of Appeal directed itself that the circumstances of the President's decision were analogous, that's the word that it uses at 118, analogous to Ries, those in Ries. And on this basis, it directed itself that Lord Staine's warning at 20 in Ries, which we looked at this morning, against creating new common law exceptions to open justice, applied. So this seems to be an additional reason why he shouldn't have continued the injunctions, the President. So we've looked at paragraphs 19 and 20 in Lord Staine's judgment. I wouldn't want to go back to them. But it's clear, we would say, that what he was concerned about in Ries was about a court conducting proceedings derogating from full open justice in those proceedings. For example, having a private hearing or making reporting restriction orders. in circumstances where there were statutory, either discretionary or mandatory, derogation from open justice provisions in play. So we've seen what the issue in that case was. It was extending Section 39 of the CYPA 1933 in circumstances where the criminal court had no power to prevent identification of S. But the basis on which this is said to be analogous in 118 isn't explained in any detail in the Court of Appeal judgment. And it's not clear. Looking at the first few lines of 119, the Court of Appeal seems to be making the point that the original orders prevented some reporting of the open court proceedings in the Haastrup case, and would have had that effect if the Abbasi case had proceeded to a full open court hearing on the withdrawal of treatment issues. They say the proceeding in Isaiah's case was public, and Zainab's would have been, but the court then jumps to a different proposition. Not that continuation of the orders would continue to prevent some aspects of the Haastrup case being reported, but rather that they will, if they're left in place, will prohibit for all time an open and informed discussion of what occurred. Well, obviously, we don't accept that they have that effect, and we would say there's much that can be publicly discussed without naming the clinicians. But the point is, if the issue before the President had simply been, as in Re S, what would be the continuing impact of an order on what could be reported about open court proceedings, that is here, the Haastrup proceedings? It would have been that some of the clinicians gave evidence in Haastrup. Very few of them. I mean, as you know, the Haastrup injunction covers a large number of clinicians. Few of them did give evidence of fact in the proceedings. And so technically, if it continues, it's restricting them being identified in a report about the end-of-life proceedings and what went on before McDonald J, in which they're named. Right, so you'd be ciphering them, as the judge did in the judgment. You say clinician A from King's gave this evidence. That's a classic court reporting restriction. But in fact, the issue with these injunctions, as you've seen, is nothing to do with open justice in that sense. There wasn't an open court hearing in Abbasi which considered the withdrawal of treatment issues. And as I've said, the clinicians in the Haastrup order were not protected as witnesses in the order. Only a handful of them were witnesses. This was about informational privacy. So this was not a derogation from open justice case, and the circumstances of the President's decision-making were not analogous to Re S. It just doesn't seem to us that the warning in Re S applies. It just looks like the Court of Appeal is bolstering its criticisms of the President in a way that's rather wrong and rather unfair, because he wasn't looking at it as an open justice case, because it wasn't an open justice case. Those are really all the things I wanted to say in my submissions, looking at the clock. My Lord's raised 2 points with me. One is, I can't claim any great expertise in this, but some expertise. My learned friend will have more. Do end-of-life cases only come to court when there's a dispute between the parents and the clinicians?
That's invariably the case. Yes, but they can also be brought if there's any doubt whether it's the right thing to do, so you don't actually need a dispute.
So Ms. Patterson is concerned that invariably that's the case, but as the court will appreciate, even if that's not the case, there are instances where the clinicians will want the view of the court, because it's not because their clinical judgment isn't straightforward, and the decision is not straightforward, and it's valuable to have that tested in court.
Ray Y is the case in point. It's a Supreme Court.
All right, Re Y. Re-Y, a decision of this court, I'm told. Re-Y, we'll get you the reference, is the case to look at on that. Thank you. And the second point was, we've knocked this around this afternoon. Does the evidence about does the inference of does the evidence and the conclusion about risk of these consequences materializing have greater force at the time and in the immediate aftermath of the end of life proceedings, however they ended? What effect does a lapse of time have? I think I've tried to deal with that. It would be foolish of me to suggest, looking at cases like Gard and Evans or Battersby the summer before last, that in the midst of a kind of media frenzy about an end-of-life case where there's a lot of coverage of it, that the risk isn't greater there and in the immediate aftermath than later on. The point I've made is that you just don't know, if the injunction's been in place, what the consequences will of it being lifted. And that can have an impetus, let me put it this way, that can have an impetus in itself. And it's recognised in the cases, that can have an impetus in itself. But I don't think I can say more about that. The other thing that was left over from this morning was Lord Stephen's question about the evidence before the court at the first stage when the initial injunctions were made. Now, in at the last part of the core volume, where we get the evidence on the discharge of applications from the two medical directors, they annexed the original evidence from the end-of-life proceedings. So it is all in the bundles as exhibits to the medical director's evidence. And in that evidence, there is evidence on which the original reporting restriction orders was made. So that there is evidence in there, not just about the substantive end-of-life proceedings, but also about the reporting restrictions. And what we were proposing to do, if it's acceptable to the court, and in particular my Lord Stevens, is put in writing the references to those bits of evidence.
That would be very helpful.
Page numbers. See if we can agree them with my learned friend, and then just put them in writing tomorrow, because Ms. Patterson has written a number of them out, but it would be meaningless for me just to recite them to you now, so that would be the best way to do it.
And there was no formal application, was there, for a reporting restriction order? There was no, you say there was evidence, but this was the court acting on its own?
Oh, no,
Or an oral application?
I was only balking at the suggestion of a formal application, because it depends exactly what one has in mind. But there were skeleton arguments were put in both cases by counsel for the trusts on the issue of the reporting restrictions order. And as you've seen, at various stages, it covered child, family, in one case hospital, clinicians.
And were steps taken to bring the application for a reporting restriction order to the attention of the press? Yeah. Thank you.
Ms. Patterson was in one of them. I was somewhere else at that stage.
She was nodding her head.
Yes. Yes, I think so. Unless I guess this further, I've achieved 5 minutes early.
Yes. Thank you very much, Mr. Miller. Well, Mr. Quintivale, I think it might make more sense for you to begin your submissions tomorrow morning.
Thank you.
Very well. We'll adjourn then and resume at 10:30 tomorrow.